Constitution, Act of Parliament, or federal law or Act of Provincial Assembly shall include an ordinance promulgated. Yes.
Yeah, that Learned Attorney General, the Parliament and its supremacy is because of its representative character. Now, if there is a law, an act of the Majlis-e Shura, and that is in conflict with a judgment of even a full court, whether that act of the Parliament will prevail or the judgment of this court.
My Lord.
It will be the act of the Parliament.
And if there is a judgment which has been rendered on the basis of, and this is where the principle of legislative overruling flows from, that if there is a judgment expounding a certain provision of a statute or the rules, that judgment cannot be overruled unless the basis or the foundation on which that judgment came about is altered or removed, which is to say, if the law, underlying law is amended, then the effect of that judgment goes. And that is where, even if, for the sake of argument, the term law includes a judgment, if the underlying, if the rules which were expounded by your lordships in that judgment...
First of all, I didn't say judgment, I said case law. Judge-made law is different from judgment. That is precedent.
So learned counsel...
And also, जो आप जो अभी बात कर रहे हैं, extrapolating from that, is the rule surely an interpretation of the Constitution or the establishment of a rule of constitutional law by the Supreme Court surely cannot be affected. Court itself changes its view. Classic example, right of abortion. Added to the Constitution, Roe versus Wade by the US Supreme Court. Taken away as egregiously wrong by in Dobbs versus something or another 2022. I think surely that is settled constitutional law.
My Lord,
please, if you don't mind,
I have to take your lordship to
now. Please proceed further. I mean, we will write a judgment, whatever we want to write.
So now, my Lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my statement.
Rahman knows shorthand.
This is not my statement. This is my understanding. Act of Parliament can be considered as law as well, but every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, तो Parliament करती है, उसको आप law भी कह सकते हैं, Act of Parliament भी कह सकते हैं, लेकिन जो judgment या case laws से आते हैं या कस्टमरी लॉ होते हैं, उसको आप एक्ट ऑफ पार्लियामेंट नहीं कह सकते, तो इसलिए उसको कन्फाइन किया गया, लॉ किया
कह भी नहीं सकते, माय लॉर्ड. और दूसरा एक और, just let's look at it from another aspect. Now 1980 is when these rules were made, and when these rules were made, if I draw your attention to order 11, order 11 को जरा देखिए.
अगर हम बहुत ही pedantic approach ले
order 11 my lord,
ये pedantic approach ले लें, ये rules किसने बनाए? किसने बनाए?
सुप्रीम कोर्ट ने.
कब?
1980.
सुप्रीम कोर्ट क्या होती है? नहीं, hang on. If you go into that approach, सुप्रीम कोर्ट क्या होती है? बताइए.
All the chief justice and the judges
sitting at home. No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So surely it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons condemned to death before their appeals came up for hearing?
This is our domestic affair. We can
No, with great respect, my lord, it is not.
It is.
Absolutely not, my lord, with great respect. This is the right of the citizen, litigants ka right hai.
From the
Learned
executive,
Attorney
it is domestic affair.
My lord, with great respect, it is
We can
not.
resolve this.
It can't possibly be.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say,
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट, सिविल पिटिशन फॉर लीव टू अपील इज नॉट अ राइट. फॉर एन अपील द रूल्स प्रोवाइड 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, suppose can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose suppose tomorrow I refuse to fix any bench, what will compel me? At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते हैं, वो भी इख्तियार चीफ जस्टिस का है. 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से. हम जब टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just
जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी,
इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ.
जी, सो
तो कोई लॉ था नहीं
जी, उस वक्त नहीं था, बट ये रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ.
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था.
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे simple, are the 1980 rules law, come within the purview of law or not?
191 की definition क्या आप
Article
पढ़ते हैं?
191.
No sir,
No.
no.
These are the rules.
These are the rules. The
But
language
it is-
says subject to the Constitution and the law. The
See,
Supreme
but
Court
what
will
is
make rules.
the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the
You
full
mean to say
court
that
of this
now
court left it
law-
open.
Now the law has been
Knowing,
promulgated, and this covers under this provision.
yes, not just this provision, it is covered under 191. This only recognizes what 191 already provides.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation
In what context, my lord?
in the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking
You
at
say
it.
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a role of executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not,
language.
you have not argued on Article 142,
मैं
because this
उसकी
is
तरफ
the
हूँ।
distribution of legislative powers.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
With respect to
any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list of item 57, it is also related to
58.
58.
Yeah.
उसके साथ 55, sorry, 55
55, yes,
jurisdiction
it is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Should be
sorry,
read
item
Why is
58.
it not coming under 55? It says
It does.
enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it
what
has
I
given
submitted,
us
sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recordic judgment. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted.
It's
Section 5
authorizing-
is covered under entry
So
55.
you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
You are not, please don't take questions. You just hear them, write them
My lord,
down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Learned Attorney General,
जब आप देखें हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want this system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. पॉइंट्स ले हम नोट करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now, I just quickly rush through my submissions. And
one question that in Order 11, the use of the word law, the term law, you think it carries the same meaning as in Article 191?
yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle, the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
Or you can call it a sharing of the burden.
sharing of
It's
the
a
burden.
huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord-
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far
No,
as Section
as
2 is
I'm not
concerned.
talking about
Absolutely.
myself.
Absolutely. Absolutely. And because what it does is...
If I don't trust them, that's the only other way. I can't trust them.
It is in this time
trust
when
them 100%.
we want the justice system to be more efficient. It actually helps when there are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185. exercising appellate jurisdiction. 184.3 is rare cases which come before your lordships under 184.3. It's actually appellate jurisdiction of this court, which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective, and Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency goes down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero.
But
This is what is being sought to be assessed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various judgments was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all the people are part of it, they think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of constitution, fundamental rights in 184.3. Otherwise, it can be ultra-vires of constitution, you do a 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law?
Of course.
Oh, you see, you are saying this is a law
If
affecting
it repeals it, yes.
That this is a law affecting having such a salutary effect. It is having this, that, and the other. So someone can say, "जी parliament का तो power ही नहीं है, तो ये law को repeal कर दें." या फर्ज करें अगली पार्लियामेंट आती है वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है वो, दैट्स गुड इनफ।
My lord,
सकती है, आपसे पूछ रहा हूँ।
जी जी।
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजेक्चर्स पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा, भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे बहुत सारी चीजें। आप फोकस कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़ जाएंगे। आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है? फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, ठीक है वो एक अलग बात है, आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना ऐसा उनकी मर्जी है, हमें आपको परसुएट करने की कोई जरूरत नहीं। आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is recording the questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say let it go back to the Chief Justice in his sole capacity. That is within Parliament's competence?
My lord, if that is so,
Learned
if it
Attorney
so
General.
happens.
Question.
Yes,
No,
Learned
not
Attorney
conjecture.
General.
This is
Yes,
to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
Absolutely,
General.
my lord. Absolutely.
Learned
It is in
Attorney
Parliament's competence, and if I may say
I'm
so, my
sorry,
lord.
you
My
have-
lord,
you
I
have
have,
provided assistance. Thank you.
I have, you know,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely,
Yes.
yes.
Mr. AG, to your right.
Ji.
Section 2 में it's provided that the bench, constitution of the bench, suppose bench is constituted, who will assign the cases to the benches? Still this power has not been given in this act. Again, there will
My
be,
lord, the committee is to determine its procedure, and then it, with regards to how the meetings are to be, this committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if two members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
What would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held, and the constitution of benches, etc. But that never happened, because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so, with regret, was a first. My lord, this is exactly what under subsection 2 the committee is to do as the first.
We will regulate through rules. They will regulate this act through rules. You
My lord,
clarify it in
ji,
rules.
the committee will determine its procedure much the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is as an SRO, as a rule, or whatever they call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing, that the committee is to first see whether the matter is, it has to come before the committee to examine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who would first determine whether the matter was of public importance and relatable to enforcement of fundamental rights, and then constitute a bench. This is this tension which my lord had also while authoring
But
judgment,
this
rendering
doesn't,
judgment.
this
This
doesn't
would
answer
be
the question whether the threshold of 184(3) is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My
Now,
question is,
there's a distinction between
Learned
what is
Attorney
filed
General.
under 184 and
Learned
the suo
Attorney
motu, and that's
General,
why, my lord.
my question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response
That
was
is
that
further
if
providing guarantees, and my only question is, are we not accountable to the litigants? The
absolutely.
Parliament is the representative of the litigants.
So
If they
Attorney
want to
General,
change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative.
And
We are
if I
there
may,
to serve the litigants.
and if I may, my
But
lord,
normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it himself. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
So
3,
judicial
my
power
lord.
is not in any way impeded because judicial power comes after the bench. is
Section
marked.
3, Section
No, you
3
see,
talks
Section
about
3
invoking of jurisdiction, and that is what I was
Section 3
addressing.
specifically states that the committee would examine. ये देखिए, the word
जी,
used
जी, जी.
is
And that's what I was
examine.
addressing.
After for examination, if the committee is of the view that a question of public.
This is exactly
So
what
it's
the
a
Chief
judicial
Justice-
power.
Yes, yes, yes. So मैं
So
यही
how
कह रहा
can
हूँ,
the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold कि ये जो ओवरलैप हो गया है कि एडमिनिस्ट्रेटिव फंक्शन और जुडिशियल फंक्शन को कंट्रोल कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice used to do. They would first examine it and then constitute a bench, और यही वो टेंशन थी जो आप पैराग्राफ 53
Please take
54
one
में आपने
question
कहा
from
था.
this side, AG sir.
Oh, sorry.
The article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship, says is the Chief Justice and the
184
judges of the Supreme Court.
184 I'm talking
जी जी,
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को डेफिनेशन जो है वो 176 से फ्लो करेगी.
जी जी.
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस.
All the judges.
No single person
Yes.
is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that-
by committee, that could be
Mr.
an
Attorney
fair
General,
outcome.
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that could be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with under Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
इसमें
In what, in continuation, and what remedy would be available to him, because this is an administrative order, it cannot be challenged in appeal, except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
My lord,
file
ये जो
and-
threshold है एडमिनिस्ट्रेटिव
Nobody's talking
साइड
about
पे
a
डे
hearing
इन डे
here.
आउट बेसिस पे हमें क्रॉस करना पड़ता है लिटिगेंट्स ऑन दिस साइड.
I'll
यहाँ पे ऑब्जेक्शन आ जाते हैं रजिस्ट्रार के कि जी ये मीट नहीं
I'll
करता.
tell you what's been happening. Number of 184(3) petitions have come up that the office has put objections. Not the judge, the office.
Yes.
जी जी, one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी, not does not come within a
उसके
parameter.
chamber appeal में जाना
ठीक है. They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ की अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ तो बल्कि वो भी जुरिडिक्शन बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पार हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का, राइट आपके सारे महफूज हैं. जो आइन देता है, जो कानून देता है। ये नहीं कि आपने 184(3) की पिटिशन डिसमिस कर दी तो वो 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज़। यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी। रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट। So I don't know what are we taking away? Back to the same question, what are we taking away?
Nothing.
इसमें इस वक्त क्या सिस्टम चल रहा है?
Actually,
184(3) में सिस्टम क्या चल रहा है?
दो सिस्टम्स हैं। एक है कि जब कोई पिटिशन आती है, जब कोई पिटिशन फाइल होती है तो वो ऑफिस के इससे होके जाती है, रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट। इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर, यू फाइल अ चेंबर अपील। सो दैट इज वन राउट। द 184(3) का दूसरा है सुओ मोटो। नाउ this actually, this provision in fact cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the three senior most, Chief Justice and two senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee where the appeal lies.
It is the 3 judges, my lord.
Three judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी, मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर समझते हैं कि दिस इज केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और चीफ जस्टिस इनकार कर जाता है कि तीनों से एग्री नहीं करता। He has all the power, more power than 3 judges sitting in the court. The Chief Justice alone, sitting in a chamber, can undo this.
And the suo moto particularly, उसमें तो और ज़्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं।
इसमें भी 3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or whatever, wherever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against
My
that
lords can
order.
suitably amend the rules
You
and
see,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते, but what when we are refusing to do that? And that is exactly what has happened.
Being 43
I think
years.
this act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all these years.
You were too polite to say that.
My lord, we have section 4,
I've read that actually.
section 5.
अभी तक जवाब नहीं आया।
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी तो उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amended
Mr.
amendment in the
General, entry
constitution?
55 says that we'll enhance your jurisdiction, तो उन्होंने एक और 84 की अपील बना दी है। enhance the
185 की भी फिर एक और अपील बन सकती है?
बना दें,
बन सकती है।
बना सकते
सेकंड अपील तो है, हमें वैसे भी बताया हुआ है हमने कि हम
Speaking
दे
for
सकते हैं।
myself, Learned Attorney General,
Parliament-
Learned Attorney
Why
General,
not a
speaking
third
for
appeal?
myself.
Why not then a third appeal or a fourth
No,
appeal or a fifth appeal?
Leonard-
Obviously, it's the Parliament. Parliament won't do absurd things, and
No,
of
it's
course,
not a question of, no, it's
you
not
know,
a question of absurdity, because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया।
नहीं, infinity नहीं है.
Parliament
Obviously,
कहती है-
you know,
देखिए,
we're talking
principle
about the
की-
Parliament here.
देखिए,
We're
Mr.
not
Attorney
talking
General,
about.
आप बात फिर आ जाती है conjecture और theory और ये और वो, बात principle की हो रही है, असूल समझने की है ना। एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
My Lord,
This is the
great
point.
respect. I would
देखिए ना, review
disagree.
jurisdiction भी है ना। अब review jurisdiction का क्या concept है कि सुप्रीम कोर्ट में finality हो गई, अब आप maximum में review कर रहे हैं। वो हमने
You know, with great respect, when it comes
ये
to
देखो ना, ये जरा
even on this plane, even on this
आसान
plane,
बात
and
नहीं है।
even on this plane, and I submit that entry 55 sufficiently covers section 5.
Again, can
even-
you go to the next point?
जी.
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And-
so I don't see how.
And in a context where this court becomes the first and the final court in the same proceedings.
That's
Where-
done. Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions. And I have placed on with my
we'll
paper book
certainly
the
look at
judgments
it,
of
don't worry.
in Baz Mohammed Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to.
There was one concern also expressed
What,
by
Madam?
Justice 𝐼𝐚𝐳𝐲,
जी, वो मैं address
which
करना
was that
Sorry.
if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे, आप कैसे address करना चाहते हैं?
उसमें एक ये बात है, मैंने अपने written submissions में ये कहा है कि आप इसको to that extent read down कर लेंगे.
इस हद तक read down करें?
जहाँ पे full court होगी, naturally appeal
Yeah,
जो
4
है
और
वो
5 को
obliterate हो
harmonize
जाएगा.
अगर कर
But
लें,
आप उसको ये कर सकते हैं, sorry sir, just
I'm just saying, if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord,
That's
ये अब
quite
15
simple.
बैठे हुए, so मैं जैसे just will say, so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
आप देखिए ना, इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटिशन आ जाती है, 9 member बेंच बन जाता है, फुल कोर्ट तो नहीं है.
My Lord would be mindful of
बात
this.
सुन
Committee
अब
would
ये
be
हो
mindful
सकता है,
of this.
हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं.
My Lord,
आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया. आप ये- इस तरह की बात ना करें.
what I'm submitting is that now it's a duty. Duty cast हो गई है इस कमेटी के ऊपर.
अपील
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल
अब ये तो नहीं हो
कोर्ट, तो
सकता.
कोर्ट
It's
तो
a
फिर
vested
अपनी
right.
मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया.
So let me just.
I think what we can do
writing,
is,
my lord.
we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them, there aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So wo to gayi.
Actually, जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी, उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं full court बनाई जाए, आपको तो कहना ही नहीं चाहिए कि full court बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMAs क्योंकि वो hearing पे नहीं गई,
but the burden at the end of the day was on us.
Question was in fact put by me, and so therefore it's not that the question was not there.
My lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशीट पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है. अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता. इसका मतलब ये कि हम एक्ट को मान रहे हैं. अगर हम बेंच पे एतराज़ कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते व्हाई नॉट फुल कोर्ट.
So मैं इसका brief एक response दूँ and then followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती.
In cases, in circumstances में ये हो सकता है, जैसे अभी भी है.
क्वेश्चंस तो सोचिए, आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से.
So let me put it differently.
ये
now
फुल कोर्ट कभी बैठ ही नहीं सकती.
नहीं, full court आप बैठेंगे.
Article 184
matters,
questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled. My lord, section 6, right to appoint.
Section 5 can be read down.
My lord, to that extent, my lords can hold that in exceptional cases and when a situation of this sort arises, that be so, my lord.
Right of appeal पे substantive right नहीं है जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not. And all of that has happened under 184.3. With great respect. With great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
Well, Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए.
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Applications of your submission तो kindly देखिए.
मैं उसको ये इस तरह से आपको कहता हूँ कि
Attorney General साहब, let's be, we are all grown ups, right?
Attorney General साहब,
can I just, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy, we don't understand the repercussion of things. Fine, I'm not saying that judges who decided that, they did what they thought at the time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा problem ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है. हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. The minute I say that, please file a reference against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. तो हमें मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं बताया उनको क्या मसला हो रहा है, उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं, वो कहते हैं हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. What are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें अटॉर्नी जनरल साहब Attorney General साहब, law reforms ordinance के तहत there is a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches, and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है, 184(3) is discretionary. Now, यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज हैं, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to see
देखिए हम सारी बात चलें, ठीक है, मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? वी द होल विल बी गटेड.
How many cases would there be, my lord?
And no limitation period is here.
ये तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been
ख्याल रखा करें ना, आप रखिए, आप लाएं कॉन्स्टिट्यूशन, चलो ठीक है.
My lord, what the parliament has tried to address here is,
You see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185, 73 से शुरू हो जाएंगे.
my lord, 1947 तो नहीं, 75 में पहला हुआ था.
एक बात है, आप इसमें there is open-ended ना.
And then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act, means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके
couldn't have taken effect.
फिर एक और छूट जाएगा ना. ये बताइए, जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया, कैन द पीपल ऑफ दिस कंट्री फाइल अपील्स एंड have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do we fear if it's
Otherwise we'll be brushing things under the mat.
1975 𝐶𝐚𝐳𝐢 was the first case under 184(3) and thereafter after 13 years it was Benazir Bhutto case 1988. ज्यादा जो jurisdiction exercise हुई है वो perhaps
But where do you
15
draw
साल
the
में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. Why brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know, because everybody's dead or whatever, long past. Go on.
My Lord, I would conclude my submissions with this. I have the written submissions along with Reliance's. I have noted down one question जिसका detail में
ये सेक्शन 6 पे भी बता दीजिए लर्नेड अटॉर्नी जनरल ये जो आपका राइट टू
counsel.
Yes, because it is already covered under Article 188 of the Constitution.
उसमें Order 26 है.
Power of the review.
जी, Order
So
26.
you have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा माय लॉर्ड का 188 पढ़ लें जो रेफर कर रहे हैं माय
188 is the Supreme Court shall
पढ़ लें जरा
have power subject to the provisions of any act of Parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power.
No, I am only asking about the change of counsel, why this provision has been created, because the new counsel will come and he will argue the whole case as an appeal, because you know the scope of the review. Normally the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try to argue the whole case again as an appellate jurisdiction.
And actually the wisdom.
I think my lord has made a very valid point. If I was to sit in a court, first question I would say, yes, where did you take this point in your pleadings? And if he hasn't, he hasn't. I mean, my answer to him would be, he can't, arguing is like arguing, but we will go by the written, you didn't take this point. खत्म जाओ भाई, वो रिव्यू में वो अपील का पावर नहीं हो जाएगा उसके पास.
Review नहीं grounds.
उसकी wisdom यही थी ना कि counsel, the same bench, same counsel.
Same
They know what
settings,
transpired last time in the hearing, what questions he had agitated.
अपनी भी wisdom.
My Lord, अब जैसे for example, I am assuming that the proceedings of this courtroom are transcribed and they are, we have the transcript desired or required. Technology can be used, but that said, if there are submissions and obviously people file their concise statements or they bring their petitions, file their responses or make written submissions, nobody can go beyond that. Now, if a counsel, the new counsel comes before your lordship and make a point which is beyond the pleadings before your lordship or any written
What is the
submission
purpose
filed-
of, what is the purpose of introducing this section? Why new counsel? We totally.
Lawyers demand. मेरे ख्याल में lawyers demand थी.
My Lord,
क्या,
वो
what is
वाली
the
बात
reason?
है जो मैं
अभी वो सवाल आएगा कि what is the fundamental right which is
lawyers का demand था या किसका litigants का demand था?
फिलोसफी क्या है इसके पीछे नए वकील को लाने की?
My Lord, न्यूयॉर्क बार का जो इम्तिहान होता है तो उसमें कोई 35% हर साल में 2 दफा होता है तो फेल हो जाते हैं. जो हमारा यहाँ पे जो सिस्टम चला आ रहा है उसमें इश्यूज तो मैं मजीद बता दिया आपको.
Mr. AG, towards right. 188 says subject to act of.
समाअत का सिलसिला जारी है और इस वक्त अटॉर्नी जनरल मंसूर उस्मान इस वक्त दलाइल दे रही हैं जो आपने मुलाहिजा किए हैं. और अब शामिल करेंगे न्यूज़ हेडलाइन.
हेडलाइंस के लिए ताउन किया है.
जब बाल हो